Very good. It looks like Mr. Gross and Mr. Trimier are in the virtual courtroom. And Mr. Gross, if you'll start and tell us how to pronounce your client's last name, that would be appreciated. And we're ready for you. You need to go off of mute, Mr. Gross.
You got it right, Your Honor. It's Emil Schneiders.
Very good. Thank you. You may proceed.
Thank you, Your Honor. May it please the court. My name is Alan Gross, and I represent the appellant Emil Schneiders in this case. I would like to review a few of the salient facts in this case. This estate involves the estate of Beatrice Schaefer, and her estate was opened up in November of 2019. The personal representative timely published notice to creditors, and 2 claims were filed by my client against the estate. The claims were filed in a timely manner. The personal representative did object to the claims in a timely manner on March 5th, 2020. Immediately upon the receipt of the objections, I spoke with Matthew Reinigans, the attorney representing the estate, and
Before you
inquired about the
Mr. Gross, that's a sticking point. You're asserting you spoke to opposing counsel, he agreed to extension, but wasn't that vociferously denied below? So where's
no, Your Honor. First of all,
corroborate that?
First of all, Your Honor, my pleading that I filed was a verified pleading, which says that I did speak with him about it, etc.
No, I'm not saying you didn't. I'm just saying, where's the evidence? There was no evidence put forth at the hearing on the motion for extension. It was argument of counsel, and as you know, argument of counsel, that's never evidence.
No, Your Honor, there was, my actual motion was evidence. It's verified. It's a sworn statement.
Argument. So, in other words, it was a clerical error by someone on your staff. That's the reason given.
Correct, Your Honor. I dictated and testified in the first hearing and the second one by my verified statement that I dictated the stipulation, gave it to my secretary, was told it was typed and sent for a signature for the.
I know what the rest of the statements are going to be. Are you saying that the judge therefore was required to accept that at face value, couldn't decide if the other side had any merit to what their denials, and had to say that was excusable neglect or good cause?
I believe the judge had, the petition was filed based upon that there was clerical error, and as the judge found, some malfeasance on my part by not properly supervising my staff. But this also, like I said, my secretary was only there 2 days, quit, and then we had the pandemic. I couldn't get another secretary. As soon as I got it, she found the tape, typed it up, and sent it to the opposing counsel. Now, he didn't sign it, and I agree, he did not sign it, and that's why I immediately filed within a very short period of time, still in April of 2020, my petition to extend the time pursuant to the statute showing good cause.
Mr. Gross, on that April 30 filing, tell me if I'm right or wrong, the personal rep filed the objection to the claim on March the 5th, and then the first document of record that you filed was on April 30. Is that right?
That is correct, Your Honor, because I had believed that I had an extension until June 5th. That's what I had documented on my system based upon my understanding, my conversation.
Without an extension, that document would have been due approximately April the 5th. Is that right?
Correct.
So the document that you filed on April 30 was already late if you did not have the extension you thought you had. Correct?
It would have been late, but again, it would have been good cause for not doing it. My belief was that my secretary had filed and sent the stipulation to opposing counsel, and that he had signed it, and that's why I had docketed my due date as June 5th, because that's the date we had discussed, that it would give me 60 days to inquire as to what happened to the money in the trust that was the Albert Schaefer Trust, of which the decedent was the sole trustee and sole income beneficiary, which she included in her will.
The extension to June 5 was just something that you had verbally arranged according to your pleading. Is that right?
That is correct.
Nothing, there's no physical stipulation filed or anything of that sort.
Other than, no, it wasn't about, I sent it to the opposing counsel, okay? After the 5th, when I realized that it had not been sent by my original secretary, who had only been with me for 2 days. Correct.
Because
So-
if I understand this correctly, opposing counsel is going to say that in no way, shape, or form was there any agreement to extend. So you have to tell us what is your best argument that you did in fact have that agreement.
Well, my testimony and my verified pleading, there is no evidence or testimony at the hearing from the opposing side, okay, that they didn't get it. The only argument is that there is a denial in their written response, which is unverified. There was no testimony by Mr. Reinigans or Mr. Trimer or anyone else that said that my facts were incorrect. There was no testimony given.
Okay.
It was
Understood.
purely
Thank you.
they're pleading.
Understand.
Mr. Gross, at the hearing, did your side offer any evidence, any testimony that could be cross-examined?
Yes, I was there. Said I would be willing to testify, to answer any questions. Yes.
And you did not respond to an order that this court entered directing the filing of the transcript through the clerk's office.
I just got that, Your Honor. I filed that, clerk, on June 20th, just 10 days after the hearing. I filed the transcript with the court.
But it did not make it into our record on appeal, and we entered an order directing that you proceed to have it supplemented, didn't we?
I did not receive any order until there was a letter on the 23rd that talked about the order, that it wasn't supplemented, but that's the first I received of that.
And you received
February
that when?
23rd.
I'm sorry, when?
February 23rd is the letter I received from the clerk of the court.
And what was done after that?
Nothing, Your Honor, where the hearing was for that.
No, I'm saying, what did you do to comply with this court's order?
I didn't get an order. What came out on February 23rd was says there had been an order that was not complied with. I didn't get an order to supplement. It talked about that the motion or whatever to supplement the record was not complied with. I didn't file a motion or anything to supplement the record. I thought it was there in the record on appeal. It shows it right on the docket that it was there.
You may proceed.
Okay. Again, Your Honor, I believe the standard here is an abuse of discretion. We both concur on that. But I believe there a good cause was shown. And like I said, the only thing that was given to the trial court was my verified motion, which was never opposed with any type of evidence, legal argument, or whatever. Now, on the issue of whether or not there is prejudice here, there the court, while it's an abuse of discretion, the burden of proof to show that the state had been prejudiced is not on me. It's actually on the estate. And I would cite to the court the Williams versus the estate of Williams case, 493 Southern 2nd, 44, the 5th District Court of Appeals. I'm sorry, wrong one. I would cite to the court on that the case of Donald versus Syndicated Office Systems, 529 Southern 2nd, 267, the Florida Supreme Court in 1988, which said, the creditor showed that the estate had been open approximately 5 to 6 months at the time of the motion, and the independent action would not unduly delay the estate's administration. When a creditor shows that the estate will not be prejudiced, the burden must necessarily shift to the estate for rebuttal. Well, there was no rebuttal. The only argument that they came up with, was saying we're ready to close, and that was just an argument by the attorney. And the attorney said that could be addressed by Mr. Reinigans, who was in the courtroom, and Mr. Reinigans didn't speak up at all. So
And Mr. Gross, just because you're referring to the hearing again, I wanted to verify with you. This court sent out an order on February 8th that was copied to you and to counsel and to the clerk's office, that the record on appeal does not contain a transcript of the hearing on June 9th. Within 5 days, appellant shall make arrangements to supplement the record with that transcript through the clerk of the circuit court, and the clerk will then send it to us. Then on February 22nd, we entered a second order, again with copies to you and the clerk and opposing counsel, referring back to the February 8th order, acknowledging that we have not yet received the record, and saying that if we don't receive it, we're going to proceed without the transcript. And then the clerk's office on February 23rd submitted the letter that you said that you had received, which says notice of inability to complete supplemental appellate record, indicating that the appellant had not submitted any directions for supplementing the record. So I'm confused.
again, Your Honor, the two orders that you just referred to prior to the February 23rd were never received by me.
But you did get the letter from the clerk of February 23rd.
Yes, it did, but
What action, Mr. Gross, what action did you take in response to that letter to find out why is there no transcript? Did you submit anything to this court?
No, I did not, Your Honor.
Okay.
No, I did not.
Because that letter does say that it identifies the two orders that were entered by this court on February 8th and February 22nd. It outlined the time period and so forth.
I understand, but it was February 23rd. We were having the hearing here. I didn't feel I had any time from February 23rd to comply with it. If I wrote a letter to the clerk to go ahead and do it, it wouldn't get here by today's date.
Do you use electronic filing, Mr. Gross?
My secretaries do, yes.
Okay. All right. Thank you.
Yes, they do, Your Honor.
Do you want to reserve any time? You've got about 8 minutes total left.
I'll reserve 3 minutes, Your Honor.
Very good.
Okay, I apologize. So again, I believe there was good cause. This estate was only opened up a very short period of time, from November till April. So it hadn't even been a year. It's been 4 or 5 months, just as the Donald case said. There was no prejudice here. It wasn't a claim that they didn't know about, because the claim itself specifically stated, what the claim was about, that there was this trust. We tried to inquire, and I did inquire as to Mr. Reinigan's, because he's the drafter of the will that specifically refers to the Albert Schaefer Trust, of which the decedent was the trustee. He says he didn't have a copy of it, so he couldn't produce it. And I understand that. It's hard to believe, but he didn't. So I was, trying to investigate, and that's why I'd asked for the extension. And when we couldn't get anything other than found out that the $1.7 million had been taken out of the Oppenheimer account by the trustee and been unaccounted for, that's it. The case should be tried on its merits. And again, this is a rule of judicial procedure. It is not a statute of non-claim. And as all the case law indicates that I gave to the court, that unless there's really prejudice shown, that it should be granted. And it's the trial court has not only the discretion, but it's the discretion to broaden that period of time. The court should have, again, there'd be no prejudice. This estate could easily go on. They also was no statements even made or nothing in the record that even though the estate may have been ready to close, that the trust was still being administered. There was nothing in the record to show anything to the sort that the trust was ready to close. And the ultimate beneficiary of the estate and the one who would be liable would be that trust. So I believe this case should be remanded back to the trial court with the instructions to allow us to file an independent legal action so that we can pursue this matter, and the case should be heard on its merits. Again, this is not, it's a rule of judicial procedure. It is not a rule of statute of non-claim. And again, there has been no showing based on any evidence that was presented, period, that the estate would suffer any prejudice whatsoever. A delay in time, which at that time was only about a month, wouldn't make any difference. That's not, by any stretch of the imagination, can that be a reason for saying you're prejudiced only because you're ready to close. It has no bearing on you had full knowledge and of what the claim was about to investigate and whatever. I would also point out to the court that the case of Williams versus the estate of Williams, which says in cases where there was no substantial delay, as in this case, and where the estate suffered no prejudice or surprise, since the claim and attempted suit had put it on notice of the substance of the claim, courts generally hold that good cause is shown, even though there is some lawyer error involved. So I would ask the court to find that there is good cause, and even if there was some minor lawyer error involved here by not following or checking up on my secretary, which I trusted, I would ask the court to find that good cause does exist. And if not, at least remand it back to the trial court so that we can have an evidentiary hearing, okay, where they can put on some evidence of this substantial delay and prejudice, because again, there was no evidence taken or put on by the defendant, or excuse me, the estate in this matter. The sole thing was an argument by Mr. Trimier.
Very good. Thank you, Mr. Gross. Mr. Trimier?
Yes, good morning, Your Honors. I'm Brian Trimier on behalf of Paula Sett as personal representative of the estate of Beatrice Schaefer. The issue here stems from the statute at issue. It's cited in the brief 733-705. It establishes a good cause standard for an extension of time to file an independent action, which is the issue in this case. Good cause, the courts have uniformly indicated that the determination of whether or not good cause exists or not is addressed to the discretion and the conscience of the probate judge. And in this instance, the standard of review, I believe, is quite important, which is the abuse of discretion standard. And we cited a few cases to the court in our briefing papers that highlight that standard, including that if reasonable persons could disagree, there's no abuse of discretion, and the review by the appellate court is a narrow one. As to issue number one, addressed in appellant's initial brief on the good cause excusable neglect issue, good cause is the burden on establishing that was with the appellant in this case. And the court considered the circumstances and determined that there was no good cause. The appellant has repeatedly tried to bring up the issue of excusable neglect and reliance upon probate rule 5.042, but they just simply do not apply in this instance. The issue is whether or not there's good cause. The issue is not whether or not there's excusable neglect. That rule that they have relied on a couple of times now, and including in their briefing papers, it only applies to court orders, extensions of time on court orders, and timelines imposed by rule. It does not apply to statutory deadlines. And in this case, this court in the Samad versus Pla case, in fact, addressed this very issue and said that it wasn't dealing with the exact same statute under 733. It was a probate case, but it was a statute that imposed a deadline for a surviving spouse to make an election with respect to real property. And they made an argument similar to the one being made in this case. And this second district clearly stated that rule does not apply to a deadline imposed by statute, which is what we have here. Like I said, the probate court considered the circumstances. There was no evidence presented at the hearing, to answer Judge Volante's question. And again, it's the appellant's burden to establish good cause. We touched on in the brief, and I'll highlight it here. I don't want to regurgitate things that are already in the brief, but we did make an argument and point out that some of the cases reference the issue of delay and diligence in addressing the issue. And there's been a number, and those are in the Donal and Devine cases. The Donal case is one that's relied upon by the appellant. And there's been numerous appellate decisions whereby the court has found that or concluded that there was no good cause. And that includes the Johnson versus the State of Friedrich case. There, the trial court, it was held that the trial court did not abuse its discretion in refusing to grant an extension where there was a 4-month delay. The Devine versus Kirkovich case, there, the court reversed an extension granted by the trial court where the motion was filed 2 months after the deadline. The Exchange National Bank case, which is a second DCA case, but back from 1976, there, this court reversed a trial court's grant of an extension where the motion was filed over 5 months after the deadline. And then finally, in the Deso Estate matter, which is a 4th DCA case from 1980, the 4th DCA reversed an extension granted by the trial court after a 2-month delay. As to the issue number 2, the court considered the matter, concluded that the estate was prejudiced. The issue there was there were no other claims filed in this estate other than these 2. They were timely objected to. The deadline to file the independent actions came and went. And then it was nearly a month later that anything was done to address it. And so I'll just say that based on
I have one question as far as the sequence of events, and I'm trying to find it in the record. The objection was filed, if I remember, March 5. That's
correct, Your Honor. The
amended verified petition says that there was a discussion about an extension, but I don't think it indicates when that discussion occurred. Is there any evidence of record that addresses that?
I'm not aware of any evidence in the record that references a specific date as to when that is alleged to have occurred.
And I mean, it is possible that it occurred before April 5th would have been the deadline to file the independent action, correct?
Correct.
And the first filing asking for an extension was, I believe, about April 30th. Let me double check that.
That's right. It
That's
is.
correct, Your Honor.
It was 26 days after.
Yeah. And it looks like in both the original petition and in the amended verified petition, there's no indication that I can see where when the discussion took place. I think in your brief, you may have indicated, or perhaps Mr. Gross indicated, that it was only a few days after the deadline of April 5th, but I don't think that's verified one way or the other in the record, correct?
I believe that's correct.
Okay, very good. Thank you. You may proceed.
Unless the court has any questions, I don't have anything further other than to say that the probate court is afforded discretion on this matter and considered the issues presented, and we'd ask that the probate court's order be affirmed.
Very good. Thank you very much, Mr. Gross. You have your 3 minutes. I would like you to address the question I just asked.
Yes,
does the record reflect when you contacted opposing counsel to request the extension?
Yes, Your Honor. It was, and again, it was only a few days after March 5th. I asked for 60-day extension, and that's how we got from the March 5th to June 5th, which is the date that I docketed. And if you look at
what in the record reflects that?
The amended verified petition, paragraph 10, doesn't have a specific date, but it says shortly after the objections to the claim were filed, the undersigned counsel spoke with Matthew Ranigan's attorney for the personal representative. and the undersigned counsel requested extension time to file an independent legal action so that he could perform or try to find a copy of the trust, as well as to find out what happened to the thing. And then I put down the extension was sought to June 5th, okay, which was a 60-day to give me a chance to do the instruction. So it's not explicitly given, but it was literally just days after the objection was filed.
But that's not what the, you agree that's not what the amended petition reflects, correct?
It just says a short time, it doesn't say a few days.
Okay.
But it was in March. It was literally just a couple of days. Again, Your Honor, most of the cases cited by the defendant, excuse me, by the appellee, you know, the delay, there was other circumstances, but there were 4 months delay, 5 months delay, 2 months delay. In this case, the due date was April 5th. My first petition for the extension of time was actually filed on April 30th. So it was only about 25 days from that date, which was a much shorter distance than any of the cases that they had cited. Again, you know, I apologize to this court for not getting the transcript there. I, like I said, thought it had been done until February 23rd, but that's my problem. But again, there is no evidence in the record, none even reflected in the court's order, as to what the prejudice was going to be to the estate, if any. And again, there was, I believe, a clerical error is shown in every case as a valid grounds for good cause. An attorney normally relies on their secretary as to things would get done. That's why I said it, and I put on the thing that I docketed the date thinking it was done until June 5th. And then again, I filed this thing way before June 5th, kind of thing. So I believe it is clerical error. Should I probably checked it and not relied on my secretary? Maybe, but that's still good cause. And the case law specifically says that even a little attorney negligence or fault should not cause this not to be granted.
Very good. Mr. Gross, your time has expired. Mr. Gross, Mr. Trimier, thank you very much. That concludes the argument in this case. The next case is SLG LSI Investment versus Capella.